Hi, I'm Sue Miller with the Wisconsin Automobile and Truck Dealers Association. In this video, I'll be addressing a common consumer question. I wasn't told about damage when I purchased my vehicle, but now a Carfax report shows it was involved in an accident. Am I entitled to compensation for diminished value? There are two key questions that go with this. First, what are dealerships required to disclose at the time of sale? And second, when is diminished value relevant, and to what extent does a dealership have an obligation to fix a problem? This video focuses on the second question, when and how a dealership may be required to make things right. I recommend watching the first video before this one, since the two work together. There are many situations where this issue can come up, but today I'm going to cover two very general scenarios. The dealership did everything right and got the question, or the dealership made a mistake and got the question. What I'm giving you are general guidelines, not hard and fast rules. Dealers and consumers should always seek their own legal counsel if they want advice specific to their situation. So the first situation, the dealership did everything correctly. In this scenario, the dealership is not obligated to fix or pay anything after the sale for information that comes to light later. There is one exception, and that's title brands. DMV generally requires dealerships to make customers whole if a vehicle is later discovered to have an undisclosed title brand. The second situation is when the dealership makes a mistake. If a dealership makes a mistake, it would be expected to take reasonable steps to make the customer whole. So, what does making the customer whole actually mean? Generally, it means the customer is not harmed by having purchased the vehicle. Let's walk through a few examples. Example 1, a title brand discovered years later. Assume the dealership did everything correctly at the time of sale. 3 years later, the customer learns the vehicle has a flood damage brand. Making the customer whole might mean a cash payment for the estimated difference in value with the customer keeping the vehicle, or the dealership buying the vehicle back minus a reasonable mileage charge for the 3 years of use, or some other solution agreed upon by both parties. What it does not mean is that the dealership buys the vehicle back at the original purchase price. The customer has received 3 years of use, and that matters. Example number 2, illegal window tint. In this case, the dealership sold a vehicle with illegal window tint and failed to disclose that not legal condition. The customer was later ticketed and asked the dealership to correct the issue. The dealership removed the illegal tint and paid the customer's fine. That action made the customer whole. Now, in this case, the customer was still unhappy because they liked the tint, and they asked the dealership to install the darkest legal tint instead. DMV did not require the dealership to do that because the customer had already been made whole. Example number 3, ABS brakes misdisclosed. In this final example, a dealership disclosed a vehicle as having ABS brakes when it did not. The dealership failed to check the not equipped box on the Wisconsin Buyer's Guide. The customer discovered the error within a few days and demanded that ABS brakes be added to their vehicle, something that could not be done. The dealership offered two options: to buy the vehicle back at the original purchase price, or to pay the difference in value between a vehicle with ABS and one without. DMV determined that either offer was sufficient to make the customer whole. Thank you for watching. If you have any questions or ideas for a short video topic, please contact me at 608-251-8024 or by email at smiller@watda.org.